Welcome to another video presentation. I'm Jeff Segal. I'm founder and CEO of Medical Justice. I'm both a board certified neurosurgeon and an attorney, and spent some time in biotech in between. We focus mostly on keeping doctors from being sued for frivolous reasons, and we have expanded what we do to address all types of thorny medical legal issues, including challenges with the Board of Medicine, assaults on reputation, particularly on the internet, and reports to the National Practitioner Data Bank, and on and on. So today, common question, can you sue a carrier? They owe you money, you're in network. Can you sue a payer if you think they aren't living up to the terms of their agreement? So let's jump in here and describe what is doable in theory and then what is doable practically. Those are not necessarily the same question. So I know I'm preaching to the choir here that third-party payers, insurance companies, don't always play fair. The documents that you sign to be in network are in legalese, they're multiple pages long, and presumably you're a network with many different providers. And yes, it's true, they don't always play fair. So underpayment is not uncommon, as well as denial of claims or anything in between. So yes, your first instinct would be, I want to sue them. Is that the smartest use of time and resources? Generally not. All right. So this is the reality. Getting paid by a carrier is often, and I hate to use the word game, but I am going to use it, is a game of documentation, meaning that if they're going to pay you what you are billing, you need to have supporting documentation to justify it. It's got to be justified with the medical need, as well as to make sure that everything that they have requested, they have received. So most importantly, and this is probably the biggest take-home message, are the codes you submitted supported by your documentation? Let me repeat that. Are the codes you submitted supported by your medical record documentation? So the answer is it has to be. And so if it is, do it right up front. Make sure that what you're submitting is supported by the documentation. Number two, are you an outlier? What do I mean by an outlier? Well, if you are in the 99th percentile for a particular procedure across the state, there's a potential that you're going to be audited. So what does that mean? It means that if all of your patients being submitted to Cigna or Blue Cross are level 5 office visits, you're probably an outlier. That's unusual. Now, does it mean that you are billing inappropriately? No, it doesn't necessarily mean that. You could have a very specific practice where you're spending an hour with each patient that is coming in the door. You block out an hour and you do very detailed history, physicals, and analyses, and it's totally justified by the documentation. But in terms of the audit, it's going to come down to the documentation. So the audit is just it's just a suggestion that you're an outlier and they may want more information. They may want to look at specific medical records to see if the claims that you are submitting are backed up by the documentation. If it turns out in that audit that your medical record documentation does not support these level 5 consultations, they may say, well, you owe us money. And here's how they do it. They'll look at 20 records, for example, say that you miscoded 50% of those. And so instead of just being liable for those 10 records, you're going to likely be liable for all of your codes, meaning that the 50% of your records that they believe that you miscoded, they will take this as a statistical sampling and then bill you for the difference. It can turn into a fairly sizable check. So how do you mitigate against that? Just make sure your documentation supports the codes that you're submitting. All right, so let's assume that you don't like how you're getting paid. First things first, pull out the agreement. Pull out your network agreement and start evaluating it line by line. And you should identify whether the language is clear and crisp or whether it's ambiguous. And you need to identify what are your options, what are your remedies for solving a particular problem. So frequently, you have to work your way up the food chain. There's an appeals process, and normally that's the way to do it, is to follow the terms of the agreement, telling you how to fight an unjust reimbursement. Frequently, it's an appeal. Could be a lower level appeal or a higher level appeal, ultimately to see whether somebody will see it your way based on submitted documentation. Um, but still, sometimes it's unclear precisely what to do. So the first thing is gather your records. You're going to have to gather the EOBs or explanation of benefits and what you have submitted into the past, to the carrier in the past, any correspondence from the payer, and as well as any conversations, notes that you've taken on the phone, and look for patterns over time. If it looks like they are turning you down over and over again, then clearly that's a pattern, and you're going to need to get this solved globally. And if you do get it solved globally going forward, you can then pull out that solution as documentation down the road that they need to pay you properly. But make sure that you have a timeline which defines all of the challenges you have had with billing, particularly with the documentation you have submitted to get properly paid. So before filing a lawsuit, before going to an attorney that's going to sue, um, see whether you can follow the internal processes to get a remedy. Frequently, by submitting the additional documentation and or using the appeals process, you will get to the answer you're looking for. So this is great news. Um, you can keep working your way up the food chain, but make sure you understand what the deadlines are for submissions and when those have been exhausted. One tool that is often underused is having your patient and their employer serve as a cheerleader for you. So, for example, many third-party payers only process claims. They don't really provide the funds. It may be the employer that has the pool of money, but Blue Cross, Cigna, et cetera, they're the ones that actually manage the claims. But General Motors or Walmart, they're the ones that actually take the risk and pay the bills. And so it may very well be that by going to HR and having your patient go to HR and having the employer that is paying Blue Cross, Cigna, and so on, they can put some heat onto the carrier, onto the claims adjuster to address a gray zone dispute. Um, I will tell you, going through the internal processes is likely to be more cost and time effective than getting a lawyer filing a lawsuit on day one. All right. So, as I alluded to, much of the large employer based insurance, the money comes from the employer. General Motors, Walmart, Raytheon, and so on. They're the ones that put the money into it. They're not in a giant pool. These are self insured organizations that have outsourced the claims management process. They don't have the wherewithal to manage claims. They have the money and they understand how to self-insure the risk, but they really do depend upon third-party entities such as Blue Cross, United Health, et cetera, to manage the claims. And those are different entities. The pool of money in employer-based insurance is different than who is managing the claim. So the claims adjuster establishes the rules. They describe what is medically necessary and what is going to be paid for, but the funder can ask for exceptions based on a process. And this is a great example. So if Johnny in shipping has a child with a rare pediatric tumor and Blue Cross is turning them down, and they said you can't get care in a specialized center, you need to get it at a generalized center. Johnny in shipping can go to HR and then try to get them to put some heat on the claims management process to make sure that his child with a rare pediatric tumor gets care in a specialized center. So is it doable? Yes, it is doable. But well, in this example, the employee, namely your patient, has worked hard to get the employer to put some heat onto the insurance company. All right, sometimes you need a helping hand. Who can help? The Department of Insurance, Department of Managed Healthcare. They can trigger an investigation or an audit. So I wouldn't start with that, but no insurance company likes to be on the receiving end of a complaint. So if you're getting absolutely nowhere, turn it over to the Department of Insurance and see whether they can move the needle for you just a little bit. Sometimes a little bit of regulatory pressure can move the process in your direction to get you to a proper outcome without you having to pay a lawyer. Isn't that great news? You wouldn't have to pay a lawyer by doing this. You just sit on the sidelines and let the regulators do their thing. May take a little bit of time, but eventually they will get around to it. And if you're on the sidelines, of course, you need to have popcorn. So legal action, typically last resort. That means you've failed at everything else. You've failed at the internal escalation, and you've tried a regulatory pathway, and you're just not getting anywhere. So you can either file in court, potentially, or based on the terms of the agreement, you may have to turn this into arbitration. And what you need is a breach of contract. So you'll need to have an attorney review whether the contract was breached. And you'd want to aggregate this. I wouldn't do this for a single claim, but you can do it for multiple claims with multiple denials, bundle them together, aggregate them, and then make sure that you have an attorney that understands legal billing. It's got to be an experienced healthcare attorney who knows about billing. Let me repeat, an experienced healthcare attorney who knows about billing, and make sure that there's a solid legal theory. We're not looking for justice here. You're looking for whether there is a legal cause of action that will afford you a remedy. Many of the in-network agreements require arbitration, mandatory binding arbitration. So I'm often a fan of arbitration, but there is no jury in an arbitration proceeding. It's usually a retired judge who acts as the single arbitrator. And going in, the rules of the arbitration are likely addressed in your network agreement. Likely you signed up for it on the very beginning without understanding what the options are. But mandatory arbitration doesn't necessarily mean that you're going to get skunked. And I will add that arbitration is often faster than litigation. The other thing is that it's not appealable. So with arbitration, most of the time, once you get the outcome, that's it. So in any event, should you sue, should you go to arbitration, it should be an action of last resort, because once you litigate, you are writing checks to a lawyer. It's going to take time, and the outcome is uncertain and capricious. It does make sense if there are, tens or even hundreds of thousands of dollars on the line. The amount is significant, and you've got a good legal theory to support the remedy. Sometimes it makes sense to coordinate with others. If you go onto physician bulletin boards or chat groups, you'll find, hey, I'm not alone. Others are getting screwed in the same way. And you'll find that if you have multiple similarly situated doctors who have the same problem, you can share the cost of an attorney and potentially turn this into class action. Now, arbitration and class action are typically do not go together, but there may be ways to potentially split the cost, split the legal cost with a number of your colleagues, particularly if it's the same type of problem, the same denial, and you've got a solid legal theory. All right, so what do I want to leave you with? Can you sue an insurance company? Yes, you can. But should that be your first move? No. It should be something where escalation has been tried and you have failed. First step, dust the cobwebs off of your contract. and make sure you know what you're getting paid for. Document everything. The more documentation you send up front, the more likely you're going to be properly paid. And take your time with escalating. If you're not making any headway, you can use regulators to hold your hand or at least to pick up the baton here. Legal action should be the absolute last thing that you do. And then don't forget, when you are taking care of a patient, the patient has the insurance policy and they typically want you to be properly paid. So use them as allies to put pressure on insurance companies, particularly if it's employer-based policy with a large employer. They often can get the job done and solve your problem. All right, that is our whirlwind tour today. If you have any questions, feel free to contact me at info@medicaljustice.com. Again, info@medicaljustice.com. And if you'd like a free 15 to 20-minute consultation about any medical legal problem you may be experiencing, you can use the QR code on the bottom right-hand side of your screen to set up an appointment. It takes you right to our scheduling module. Again, a free 15 to 20-minute consultation about any thorny medical legal problem. Go to the QR code, the bottom right-hand portion of your screen. You can also easily find it on our website, medicaljustice.com. So in short, for over 2 decades, we've focused on keeping doctors from being sued for frivolous reasons, helping doctors manage and resolve Board of Medicine complaints, hospital credentialing issues, national practitioner data bank reports, and assaults on online reputation, and on and on. In any event, we will see you next round with another video presentation on ViewMedi.